Good morning, all. This meeting of the Joint Select Committee into Finance and Legal Affairs is now reconvened. I want to welcome all of you who are in attendance today to assist us in our inquiry. And I want to welcome our viewing and listening audience. This is the 20th meeting of our committee and our third public hearing into the feasibility of widening the availability of non-custodial penalties in the criminal justice system. I want to advise members of the public that you may send comments and questions to us via the Parliament's various social media platforms. Now, this is I don't normally like to use the word auspicious, but for want of a better word, this is indeed an auspicious occasion because this is the first time after a proper protocol has been worked out for members or members of the judicial system to come before a parliamentary committee. And we are so happy that so many of you have made yourselves available to assist us in this inquiry. So I see Master Morris Allen has attended in spite of what must be a very difficult situation, and I want to thank her especially for that. So what I will do is I will like you to introduce yourselves so that the members of the viewing and listening public will know who are the persons in attendance today. So, Mr. Mark, may we start with you?
Jerome Mark, Deputy Court Executive Administrator.
Good day. Vanessa Garcia, Deputy Court Executive Administrator for the Criminal and Traffic Division.
Good morning, Madam Chair, members of the committee. I am Jamie Filbert, Legal Research Officer, Judiciary.
Good morning. I am Narala Bansi Sukai, Registrar and Marshal of the Supreme Court of Trinidad and Tobago.
Good morning. I am Christiane Morris Allen, Court Executive Administrator of the Judiciary.
Good morning. I'm Wendy Lewis Callender, Deputy Court Executive Administrator of the Family and Children Division.
Good morning. I'm Carleen Cross, and I'm the Children Court Administrator, Family and Children Division.
Good morning. Rikab Ali, Deputy Court Executive Administrator, Judiciary.
Good morning, Stephanie Burke, Family Court Administrator, Family and Children Division.
Good morning, Johanna Orlando, Judicial Research Council 1.
Good morning, David Basil, Director of Court Research and Statistics.
Good morning, Anderson Gordon, Court Planning Director, Judiciary.
Thank you. I'm the chairman of this committee, and my name is Sophia Choate. I will ask other members of the committee to introduce themselves to you, starting from my right.
Good morning, Clarence Rambarat, Vice Chairman.
Good morning, all. I'm Vidya Gaidin Gopi Singh, member.
Good morning, everyone. Sherry-Ann Kuchto-Coburn, member.
Thank you. So that those listening and looking on may remember what the objectives of the inquiry are, I am going to read them out. 1, to assess the efficacy of non-custodial penalties in dealing with the backlog of criminal cases. 2, to determine whether non-custodial penalties may ameliorate high recidivism rates. And 3, to ascertain what are the critical requirements or prerequisites for the wider application of non-custodial sanctions in the administration of justice. At this point, I will ask Master Allen to make a brief opening of about 2 minutes, if possible, so that we can get the hearing going.
Thank you very much, Madam Chair. The Judiciary wishes to thank the committee for the invitation to be present here today and to submit comments on the feasibility of widening the availability of non-custodial penalties in the criminal justice system. We note the objectives of the inquiry and have received from the committee particular questions which we have sought to answer in our written responses. The term criminal justice system presupposes that there's a seamless system known as the criminal justice system. And unfortunately, it is the experience of the judiciary that the term is somehow juxtaposed in the public mind with the judiciary. The judiciary, through its criminal courts, is just one of the players in the system of criminal justice. Its mandate is very specific and is delineated by law, both statutory and common law. It is of critical import that all players in the criminal justice system are placed in a position in which they are able to play their parts efficiently and effectively in order for the system to work. These players include police, criminal investigators, Office of the DPP, Forensic Science Center, medical practitioners, witnesses, prison service, legal aid, public defenders, probation services, health, private bar, the judiciary, and the public. Each agency and group of actors has a specific role and is not able to encroach on the role of others. There are, however, some instances in which there can be some developmental cooperation and sharing. We have seen this in the development of the Juvenile Court project, which yielded the Children Court system and the Family and Children Division, and in areas such as the development of the ICCS and the Drug Treatment Court, and in cooperative works with St. Anne's. These opportunities are cherished. The judiciary's role is to hear and adjudicate in matters in which a charge has been laid. When adults are charged, the judiciary's role ends when the sentence is pronounced. When children are charged, the new system provides for the court to play a monitoring role after a child is sanctioned. The children's system also provides for the child to be assessed and for sanctions which differ greatly from those available to the judge in matters involving adult offenders. In terms of judicial administration, policies are oft-stated in rules of court, practice directions, and practice guides, and other policy statements which may affect the way in which the judiciary conducts business. It is trite law, of course, that the judiciary determines its own procedure. The system of common law provides official guidance and sets policy by the doctrine of binding precedent and the hierarchy of the courts. This having been said, members of the judiciary and the court's administration are not without personal opinions as to improvements which can be made to our system of criminal justice. In an effort to assist the committee today, the court's administration has solicited the views of judicial officers, the Mediation Board, the Judicial Education Institute, among others. They have reviewed statements of Chief Justices, looked at international trends, and looked at documents by the judiciary or judicial officers which are in the public domain, including the Drug Treatment Court policy, as well as such documents and treaties as the 2016 Bail Support Program Summary Report. And in those circumstances, as I have indicated, Madam Chair, we have submitted written responses, and we are here to assist the committee in any way in which we can.
Thank you very much. We have received your written bundle, and we must commend you and your team for the work which was put into it, and it has been tremendously helpful to us simply by reading it. And we hope that we may be able to focus on a few of the aspects of it this morning. Mrs. Gaideen Gopi Singh, would you lead off?
Thank you.
The public perception is that the criminal justice system is not seamless. We have hiccups, we have resources issues, and from one of your submissions dated March 11th, 2019, your submission stated, and I quote, that the children court is structured in such a way that monitoring and evaluation of a child offender begins when he or she enters the court system and continues post-sentencing. My question is, usually prosecutors and so would want a custodial sentence for most of the offenses committed. What role and function does the judiciary play in informing prosecutors that there are alternatives to custodial sentences? That's the first question, and when you answer, then I'll take the subsequent one.
Thank you. First of all, the Children Act, I believe at section 59(2), and please, I'm asking my team to correct me if I'm wrong in citing the section, provides for really a smorgasbord of sanctions which can be brought in a situation in which a child has been charged. I believe, again, correct me if I'm wrong, I think the list is so extensive that the subsections go from A to O. So it is in this way that the prosecutors are aware of the various options. And what can also be done, and what is often done, is that there's a combination of sanctions which may be used. Those sanctions include things, for example, such as counseling, counseling not only of the child, but also of the members of the household and other people who are surrounding the child, community service orders for the child, various types of very specific orders as well are cited therein. Also, in developing the children court system, as I had indicated, there was great cooperation among all of the players. And it was at that time, I think, that we were able to educate everyone, ourselves included, on the whole question of the difficulties facing children, number one, the questions of youth development, also on the question of the new science, which tells us that between the ages of 14 and about 25, a child's judgment is not yet fully formed, and that a lot of maturation takes place during that period. And judiciaries worldwide have been addressing this particular issue. So you will find that there's an entire movement worldwide in the area of child justice. And therefore, the prosecutors, just as the police service, etc., are all more aware of it. And together, we have managed to work out something.
Yeah. Do you have any system in place, or the judiciary, I should say, have any system in place for monitoring and evaluating post-judgment for these children?
The legislation allows for the court to monitor children post-sentencing. And in that event, a child probation officer is assigned to monitor. In some instances, apart from child probation officer, for example, for peer resolution, we also assign adult volunteers. So apart from the child probation officer, you have an adult volunteer monitoring what is happening with the child.
And how effective is it? How effective?
So what you have now is you have another phase called monitoring hearings, where the child is brought back to court together with the probation officer and all those persons as part of the team who are part of that monitoring exercise.
And would you say there are sufficient probation officers to deal with all these matters and cases?
At this time, no, but we do know that there is approval for a cadre of child probation officers to service the 3 court locations, and they have, some of them have been recruited, and we're about to receive 5 of them in the North location. But we expect that we may have about 18 child probation officers assigned specifically to the court.
And your role and function, do you have like mediators on board to deal with matters before the court and before post-sentence, before sentencing, like mediators?
At this time, we only have mediators in the family court.
Thank you, Madam Chair. Just one follow-up question. You indicated that you also utilize adult volunteers. What is the process involved in identifying and bringing those persons on board, and what, if you can give us an idea, who are the persons who would become adult volunteers?
Sure. What we had done in the project and subsequent to the project is we advertise for adult volunteers. An adult volunteer could be a parent, a teacher, a police officer, a law student, a social worker, particularly anybody people from different walks of life. And what we did is that we screened to ensure that we have a very varied group, and they would have gone through a period of training for over 4 days with youth volunteers. Subsequent to that, they would have been vetted.
Thank you. Since we are on the issue of probation officers, we've spoken about the numbers of probation officers in relation to cases involving children. What would you say is the position with respect to resources in terms of adequate numbers of probation officers for regular courts?
With respect to the criminal courts for adult offenders, it has been a challenge in terms of the timely submission of the probation officer's report once an order has been made. That is one challenge being faced by the judges of the criminal jurisdiction.
I see in the comments by some of the judicial officers were saying, one, the reports take a little too long to come. But there was one comment where a judge suggested that the probation officer was not independent. When such a thing occurs, is there a mechanism whereby the judiciary may bring its concerns to the chief probation officer?
What you will find in a situation such as that is that the judicial officer will direct the registrar to bring concerns to the chief probation officer.
And has the registrar, well, this one is directed to you, Mrs. Nirala Bansi-Sukai. Have you written to the, I suppose it would be the permanent secretary in the relevant ministry, Ministry of National Security, with respect to the impact felt by the judiciary with respect to the inadequate numbers of probation officers to service the courts?
As registrar, I have not sent that correspondence, but correspondence was sent to the relevant ministry from the judiciary on behalf outlining the issues that we currently experience.
And have you had a reply, a positive reply, I should say?
If I may, and what we should also say is that that has not been sent to the permanent secretary in the ministry, but instead the discussions and the correspondence would have been with the chief probation officer. Now, this isn't a one-time event. This is something that has happened over a period of time. And oftentimes, it may deal with the work of a particular probation officer, etc. And then what tends to happen is that the chief probation officer will address it either through training with the officer or may, for example, suggest that the officer is not particularly suited to that aspect of the work, but may be better suited to another aspect of the probation work.
Thank you very much. I read your submission, and there's a significant part of it deals with the drug treatment court. I wanted to know, I had not seen any reference to breathalyzer cases, and going back to the debate on that piece of legislation to introduce breathalyzer, an issue, and it appears in the legislation, there is provision for rehabilitation and for addiction counseling and addiction treatment to play a role in final sentencing. So my question to you is, what has been the experience with the implementation of the breathalyzer legislation, and what role has rehabilitation and addiction counseling played in the final sentences? Thank you.
Thank you very much, Chair. We do not have stats specifically on the question of matters brought to the court after breathalyzer tests, I'm afraid. So that is basically where it stands, in that we are unable to identify those specifically as opposed to anything else.
Okay, would you be able to make a further submission after you have had the opportunity to maybe check with judicial officers or check with the court?
Yes, I think we can.
I raise that because my experience, I support the breathalyzer, but I'm always mindful of striking the balance. And the truth is that while we're discussing non-custodial sentencing, for people in rural communities who must have private forms of transport, the imposition of a ban on driving for 3 years is far less welcome than the imposition of a custodial sentence. Because a ban on driving for 3 years really sets back a family living in a rural community. And while I support the objectives of breathalyzer, if you look at compared to urban communities where opportunities for transport and alternative transport exist, it works severely on persons in rural communities.
Thank you.
Is there, or has any consideration been given to affording these persons, well, drunk drivers, the option to go to the drug treatment court? Is that at all possible within the setup?
The drug treatment court program is an option for persons who have been charged with non-violent offenses. So yes, it is possible that persons can be directed to the program.
And is that done so as a matter of practice in the courts? because the average person may not know. He may have been held over the course of a weekend and may have been brought to court on a Monday morning, let's say.
Okay. Upon being charged, the police officer can make the recommendation. At the end of the day, eligibility to the drug treatment court is solely within the discretion of the DPP. But once a person has been charged with a non-violent offense, and that person has not been a repeat offender, whether possession of drugs or of substance abuse, alcohol, that person can be referred to the drug treatment court. The drug treatment court, though it's operational for adults, we are also in the planning phase of rolling the drug treatment court shortly out for the children court also.
Okay, I'm also interested in the extension of the court, because I see from your bundle at page 49, we have drug treatment courts in San Fernando and in Tunapuna. Has there been any consideration given to one in Tobago?
The drug treatment court really began as a pilot, and so therefore when you see that, you're seeing the reference to pilot. Recently, with the passage of the Criminal Division and District Criminal and Traffic Court Act, provision has been made for the drug treatment court unit, and so therefore for taking it out of pilot stage into full use for adults. With the Family and Children Division Act, provision has been made for it to have wide operation and full operation in the children court. And perhaps if my colleague can speak to a point of that.
So the administrative process has been worked out, and the two committees have been formed, which would be the drug treatment committees for both North and South handling Tobago as well. And they're now looking at all of these administrative processes together with the legislation, etc., to finalize their process. What I'd like to add is that the court is challenged by the fact that there are no drug treatment facilities in Trinidad and Tobago that are set up specifically for children. And so that is something that we've been talking to our stakeholders about.
So the drug treatment court rollout post the pilot project, is this intended to be only for children, or is it for both adults and children?
No, the pilot project was an adult project. The Family and Children Division Act, which of course came before the Criminal Division Act, the Family and Children Division Act specifically made reference and provided for a children drug treatment court. And hence, the Family and Children Division have been developing that aspect of it. The Criminal Division legislation, which has recently been passed and proclaimed, now makes provision for the drug treatment court for adults. We're at this time about to take the note to Cabinet for the staffing, the specific staffing for units such as the drug treatment unit in the adult courts.
Thank you, Madam Chair. In your submission, you indicated that, and I quote, "None of us believes that the use of incarceration, therefore, has been very effective in reducing the incidence of juvenile offending." Do you have any data to support that belief, one? And two, what are the alternatives to incarceration of juvenile offenders?
May I be permitted just a half a second to pull up that portion of the legislation, please? Section 59(2) of the Children Act provides that where a child charged with any offense is tried by any court and the court is satisfied of his guilt, the court shall take into consideration the provisions of any written law enabling the court to deal with the case, and the court may A. dismiss the charge, B. discharge the offender on his entering into a recognizance, C. discharge the offender and place him under the supervision of a probation officer, D. place the offender in the care of a fit relative or other fit person, E. commit the offender to a community residence appropriate to the age of the child, F. order the offender to pay a fine, damages, and costs, G. order the parent or guardian of the offender or person with responsibility for the offender to pay a fine, damages, and costs, H. order the parent or guardian of the offender or person with responsibility for the offender to give security for his good behavior, I. make a supervision order as described in Section 25K of the Children Authority Act, J. order that the offender be deemed in need of care and protection and referred to the authority, that is the Children's Authority, which shall investigate and seek any appropriate order of the court with jurisdiction in juvenile matters. K. make an order for counseling, any other rehabilitative intervention or treatment, or for psychological evaluation and resultant assistance. L. make an order for community service. M. order that no conviction be recorded. N. order that the proceedings be sealed and not divulged without an order of the court. And O. make any other order as the court deems fit. Subsequent to the passage of this, with the Family and Children Division Act, there were other things which were instituted as well. One was referred to the Children's Drug Treatment Court. The other was referral to peer resolution, which is a particular process in which children who have been trained and are on board as child peer volunteers or peer assessors question the child, etc., and determine the sanctions which should be afforded the child. Aside from this as well, provision was also made for the court to have the parents show cause why, regardless of anything which was to be done where the child was concerned, the parents should show cause why they should not be either fined, etc., or should not be brought for counseling, etc., in light of should I say, the possibility of their negligence that may have contributed to the child's offense.
Has it been found that we have sufficient community residences and people significantly aware so that you can, in fact, utilize some of these provisions as provided here?
What I would say is no, that there are not sufficient community residences. The existing community residences really, they are challenged because they are not equipped to handle the children that we are seeing before the court who are high risk, medium to high risk, and children who might be in gangs, etc. These homes cater for children who are sometimes orphaned and who have other issues, and they're in a different category. We really have to, I think, invest in establishing some community residences that are appropriate for children who are at high risk, that are well equipped and staffed with professionals who can make the necessary interventions into these children's lives, our children's lives. Because sometimes children find themselves in situations that are not of their making. And so we have to put things in place to ensure that the appropriate facilities are there, a home away from home, but yet structured enough and with intervention programs to get them back on track.
So in the absence of adequate community residences, is it that these children are in fact incarcerated, like adults?
Yeah. No, these children are not incarcerated. You find that there are alternative programs that we would try to find, but placement is in fact an issue. It is the last option because a child, of course, we prefer to place a child with a family member or with someone who's responsible for the child. In a lot of those circumstances, we can't send the child back to the home. And so that we go through a process of trying to get the child into a safe and secure place. It's very limited. And as Mrs. Lewis-Callender said, the type of child that we are introducing into these homes, the homes are just not equipped for it. So we are introducing a child who is maybe just 16 or 17-year-old boy presenting with some type of mental, that child needs some type of mental evaluation. And you're placing that child in a home where there are just children, ordinary children, who are just orphans in that home. So that mix is, of course, not healthy.
Senator Biko.
Thank you, Chair. Apologies to the committee and to our distinguished contributors for my tardiness today. However, it doesn't diminish my view of the importance of this hearing, and I wish to raise a question to you regarding pages 59 to 66 of the report, which speaks to a national parole system. And I want to submit that faith in the system overall, especially for the persons who are incarcerated or who are offending, may assist in mitigating against recidivism. This is a hypothesis because it's not founded in theory. This is just my hypothesis, right? So your submission from the Judiciary on the role of a national parole system was very extensive, and can, if successfully implemented, engender trust in the system. That is my humble view. Specifically, the one-third rule was declared deficient by the Judiciary, citing lack of structure, objectivity, transparency, and qualitative evaluation. And you advance that a national conversation is required on the parole implementation report. And I want to submit, I want to defer this decision to the chair, to the members of this committee, that this may be outside the ambit of this inquiry, but can form of course with the chair and the committee's concurrence, the basis of a subsequent inquiry where the judiciary is at the center of it. That is if it falls within the remit of this committee. Because I feel that it's very important for us to address that conversation that you have cited. And in effect, you basically cited that we should have a parole authority and a parole board. And if you can get any comments on that, which in effect would start this conversation, but may not be able to conclude it given the scope of this inquiry. Chair?
Thank you, Senator Biko. I believe a parole bill has been drafted, but I am not sure whether it has in fact been tabled. But certainly that is something we can look into.
Would we be able to ask the judiciary to comment on that section of their submission regarding the parole authority?
Well, the thing is, if a bill has been drafted, it may be inappropriate for them to comment at this stage. If the bill is about to be tabled, they may have already sent comments or had an input into the drafting of the legislation. Vice Chairman?
Yeah, thank you. Master Marisol, and I want to ask 3 questions which would really bring into focus the objectives of the inquiry. The first is to ask you to summarize for us the performance of what currently exists as non-custodial sentencing. 2, to comment on the feasibility of widening, which is really the word we use in our objectives, in our statement, the feasibility of widening the availability of non-custodial sentencing. And the third question is to ask you, in widening the availability, where should we focus on, and how do you see it working? Thank you.
Thank you. That's a tall order. Nonetheless, together we will try our best. First of all, if I may be perfectly candid, I believe that in the children court, we've gotten it right. Of course, the external resources and the internal resources are the areas which must be beefed up. In the adult system, I am of the view that it has not been working as well as it should be working. I think we had great hopes for community service orders, but unfortunately, I believe that the process is far too cumbersome. You will find, for example, that there's certain information, and that is referred to in our submission, there's certain information which a probation officer needs to give to the judicial officer first. But with the fact that our probation officers are swamped with work, and in some areas there's not a community service officer at all, it means that the information does not come to the court, and therefore the court is not able to make a community service order. We are aware, for example, that with drug treatment, as in our criminal system, only the DPP can compromise criminal charges. But the DPP is someone who is swamped with work. And when the sign-off of the DPP is required for each person to be admitted to the drug treatment program, again, you have a bottleneck. Surely we can work out some sorts of systems that can make things like this flow far more easily. In the adult system as well, I see a very strong need for a parole system. Madam Chair, we cannot, as a country, just keep incarcerating people. I look particularly, for example, at the question of incarcerating children who, like any adolescent and young adult, have done some stupid things. But at that point, to cross them out of society is not something that should be done. Really and truly, I'm of the view that no child really reaches there on his own. It's a combination of factors and a combination of circumstances. And we have to do, as a country, everything that we can do to ensure that we give that child a real opportunity to turn around. That is not to say, and statistics actually dictate, that about 10 to 15% of child offenders will be life course, long-time offenders. But you have another 85%. And it's been interesting, especially where the Children Court and the preparation and the Juvenile Court project work that we were involved in has brought us quite close to a lot of children who have run afoul of the law in one way or another. And the thing that really has struck me is the fact that the children are so angry. And there are two things, as I've said to my colleagues only recently, there are two things that really struck me in talking to all of those children that we have spoken with. And I have seen anger and I have seen embarrassment. And with the embarrassment comes a defense mechanism that causes the anger to grow. Why is there all of this anger? I think we need to have a national conversation on how we raise children. I honestly, and I say this from me, I honestly feel that we are failing our children. And our children are going to be our adults and are going to take our country forward. Our children are the people who are going to pay our pensions. We have to think about these things. Our children are the people who have to develop the society. And far too many of them are coming before these courts. When we sought initially to get some sort of baseline data as to the number of matters we expected to come to the Children Court in the space of a year, we thought that we were being a little excessive in saying that we expected 1,500 matters to come before the court in the space of a year. Within 3 months? Within 3 months, we had crossed that figure. For society as small as ours, that does not augur well. So we need to strengthen these non-custodial options. We can't be locking up our children. We also need to strengthen the non-custodial options for adults, because some of those adults that are before the courts are also within that 14 to 25 age group. We consider children to be under the age of 18. Once you cross 18, you're an adult. But what the science tells us is that the maturation process really goes on to about 25. And I'm sure if we were to analyze, which we have not yet been able to do because of our systems, if we were able to analyze the ages of people coming before the courts, the adult courts, we'd realize we have a lot of 18 to 25-year-olds as well. So we need further work.
Thank you very much, Ms. Allen. In terms of, I gather that you are advocating, if we have to widen, we widen in respect of children, and we strengthen in respect of both offenses relating to children and offenses committed by adults, sorry. In relation to adults, you've used the word strengthening, but do you see us widening the availability of non-custodial sentencing for adults? And if you do, in what areas?
Yes, I do. Improving the processes, because we do have tech community service orders, very important. Parole is not yet there. Hopefully it gets there. That will be extremely important. Drug treatment. By the way, a lot of the people who are coming before the drug treatment courts are in the early 20s. So again, stronger support in drug treatment, widening its span. And we also need to have some wraparound services for the adults as well, the same way in which we have the wraparound services for the children, because there are counseling services that are necessary, social services that are necessary.
Thank you, Master Allen. Senator Beaker, you had a question?
Thank you, Chair. My question takes us to pages 17 to 19 of the submission regarding mediation and out-of-court disposal. And I have a preliminary question just to inquire, because on part 13, the mention was made, which is on page 19, community mediation centers under the control of the state. Are those under the control of the Ministry of Community Development and Culture?
I'm afraid I am not aware as to what ministry it falls under at present, the community mediation centers.
So given, notwithstanding that part, but the strict nature of the relationship regarding the work of the community mediation centers, can you explain what criminal offenses they mediate there? Or general knowledge of the work of those mediation centers, so we could understand regarding non-custodial sentencing what they actually do?
Well, perhaps I could just interject here. I think what had happened is there had been legislation in place to permit mediation for minor criminal offenses, but that legislation, I think through inadvertence, had been repealed. I don't think that legislation has been reenacted to permit that. But Master Allen, perhaps you or a member of your team could indicate whether you support such a reenactment to deal with or to provide for mediation for minor matters, minor criminal offenses.
Madam Chair, I would like to refer in particular to page 16 of our document and the comments of the Mediation Board. And I think that these comments are very valuable in this regard. Offender discusses the question of offender-victim mediation as an option. But mediation in criminal matters is extremely risky. And there are so many considerations which must be taken into account. Matters of a nonviolent nature, first of all, that should be the first line. Secondly, of course, there's a question of what is the role of the DPP? Once a charge has been laid, and it's a matter against the state, and it is the DPP who can compromise a criminal charge. So, there's a lot to be considered. It's not something, to my mind, that you should just step into very calmly. And you have private complaints. That's a different situation. Those are not offenses against the state, and some of those may be matters which can be addressed. But participation must be voluntary. There must be no violence. The question of the equality of the parties is extremely important. There are so many things to be taken into account.
Do we have any data from the time when it was possible, when it was legislatively possible for parties, like neighbors who bring each other up in court for use of annoying language or for pelting stones and that kind of thing? Do we have any data as to how the mediation process worked when it was possible for them to go to mediation? I know it was some years ago.
The referrals weren't coming from the court really at that point in time. They were walk-in centers. So you may have found that someone may have come with a private complaint to the court, but at the same time they went to the walk-in center. So it wasn't really a referral from the court. So there's really, my recollection of it was that it was really not used by the court. As to, of course, matters against the state, it wasn't used at all.
Thank you, Chair. I just would like to retract a little with respect to child offenders. And some of these child offenders may have presented themselves with some mental illness. How does the court deal with children who have presented themselves with that particular symptom or disease? That's one. And two, when I have looked at the data presented for the number of persons who have had matters adjourned, awaiting the sentence report, and I look at the law term 2016-2017 and then 2017-2018, the number of persons who had to wait for this report was more than doubled from 2016 to 2017. So if perhaps one of the objectives of the criminal court justice system is to expedite matters through the court, I am trying to see how the court is going to reconcile the expedition of these matters, and yet we have delays in the reports from sentence. Are they working in silos, or are they working in tandem with the judiciary, the sentence hospital?
Excuse me, Chair, was that focus on children, or is the focus on both children and adults, please?
Yeah, for both children and the adults with the reports from St. Anne's Hospital.
I will deal generally with it, and then my colleagues will speak specifically to the children court. There is at present, I understand, there's at present a small committee where with Judiciary and the St. Anne's Hospital working on ways in which these assessments can be speeded up. I'm afraid I don't have before me, or really my knowledge, what exactly where they are on the process, other than to state that it is my understanding that one of the things that is being implemented is a form that would state more specifically the nature of the concern and the nature of the assessment to be done, as opposed to it being such a broad-based request that comes. So that's thing number one. It takes a long time, and yes, an average of 18 months, and it is one of the things that when I speak about the criminal justice system, the court can speed up certain things, but when we are dependent on the other agencies to do certain things, then that really tends to slow down the course of case flow management. So there's a specific issue where children is concerned, and I'll ask my colleague to speak to that.
So when a child needs to be assessed for mental health, and the court makes that order, the child is committed to St. Anne's, and the assessment would usually take about 2 weeks. The problem with that is that St. Anne's is really an adult hospital, and so there are no provisions within that facility for children to be separate from adults, and that poses a very serious problem. And so that is something that, as a country, we need to work on, because there are no mental health facilities for children. In addition to which, at some point in time, we only had one child psychiatrist, and that's a problem. So in terms of the assessment of a child, depending on what is presented, that, the resource is not there. So generally, that is something that we wanted to raise, that we really need to focus on the needs of the children who come before the court in terms of mental health, the fact that there isn't another place for them to be assessed, and if there is need for long-term stay, there isn't a facility for a child.
So where then do these children go? They remain incarcerated. Where do these children are placed, and where is a safe place to house these children?
Well, so far, they have been working with the court and trying as far as possible to put them in a particular area that they feel would be safest for them. But there is no other facility.
Master Allen had mentioned 18 months for a report. So during this 18 months, the person remained incarcerated?
Once an order is made for psychiatric evaluation, as Master Allen mentioned, there's a set form. The court will submit relevant information to St. Anne's, and upon receipt of that document, the psychiatrist will then send to the court an appointment date and make certain requests for particular information. And during that time, yes, that person remains incarcerated. St. Anne's has been working with the courts due to their limited accommodation as well as the limited availability of trained personnel at the hospital. Sometimes they do some of the assessments at the Golden Grove prisons or at the maximum security prisons, depending on how high risk these prisoners are. But the answer is yes, they remain incarcerated.
I just wanted us to look at, or go back to one of the issues raised earlier, and that had to do with community service personnel, or personnel who would assist in determining whether someone ought to do community service or is suitable for community service or has done community service. Now, Master Allen, you indicated that we don't have such personnel in all courts. Can you give us an indication of how or what percentage of courts we have adequate personnel in?
It's not in the courts, it's actually the probation officers. So it is the responsibility in the Act is for, there's a lot of responsibility in the Act for probation officers.
So I don't mean to interrupt you, but are they based at the courts?
In some courts, we have, on some magistrates' courts, we have a probation officer. In most of the courts, as a matter of fact, there's provision for a probation officer. They're not necessarily based there all the time in all courts, but in some courts, they have office hours when they are there. But
we have those probation officers performing those duties in each court, or are there courts without this facility?
I believe at this point in time, I can't be 100% sure, I'm afraid. My understanding is that there's at least some service, not a full service, but some service, even on a rotating basis, to each court.
Mr. Morris-Allen, I just have two questions. The first is, you had mentioned before the bottleneck at the DPP's office, with the DPP having to sign off on or authorize discussions on non-custodial sentences. Is there a model that you can recommend, or what are your views to deal with the bottleneck at the DPP's office on this particular issue? And I'll come back to my second question.
At this point in time, I'm afraid I don't have an answer to that. I think it is something that the DPP may want to be heard on. The DPP has a lot of work.
But just to ask you, is delegation of authority an option?
I really can't tell you. I can't answer that question because I do not know how the DPP's office works in that regard.
Okay. The second question deals with cannabis is still an offense, and you can be prosecuted for possession of the smallest amount. Do you see an opportunity for, in terms of non-custodial sentencing, and the subject of this discussion, the feasibility of widening the availability of non-custodial sentencing in the criminal justice system? Do you see this area, possession of cannabis, being an area that we should be looking at?
I will answer that question from my personal view. And so this is Christiane Morris-Allen speaking. And my answer is yes. Small amounts of cannabis, I really don't think we should be locking people up for.
Senator Beaker.
Thank you, Chair. I had to take some time to collect myself after that response, but we are very grateful. Madam Chair, the question I want to turn to, it carries us to page 40, pages 40 to 42 of the submission regarding the family court and payments. And I want to just highlight the comments of the judiciary regarding, it's stated on page 40 that custodial sentences are applied in default of payment of maintenance monies as ordered by the court. But on page 42, in paragraph 1, the judiciary submitted that after custodial sentencing, a payer becomes unemployable, which largely defeats the entire purpose of sentencing in the first place, because the party that loses out significantly would be the child, to whom the system was seeking to protect by penalizing the delinquent parent. So the question is, has judiciary engaged in discussions with stakeholders to develop a system which will facilitate automatic garnishing of earnings? Chair, there's a question.
Good morning. So the option of garnishing of wages actually is a relief that is available to customers of the court. It is not automatic, so it has to be applied for by a particular customer. So someone can come to the court and indicate that they would either like their wages to be garnished or they would like the wages of the payer to be garnished. So it's something that is already available to customers of the court.
And if the judiciary could enlighten us, Chair, regarding the submission in the second paragraph on page 42, where they stated that the non-custodial sentencing, whilst it should have ideally a financial component so the payer can continue paying, it should also not form part of the criminal record of the person, because then that also defeats the purpose. Can we get some expansion on that point for us?
Madam Chair, I'm sorry to intervene. Before we give a response to the question, may I just request briefly that these proceedings be held in camera? Just a brief moment.
Is it to respond to this question?
No, it's not to respond to the question, but it is to treat with an urgent issue.
Certainly. Would you prefer if we suspend? Okay, so we can suspend for how much time do you need?
Just about 10 minutes, please.
Certainly. So we suspend and we'll return at 11:35.
I'm grateful. Thank you.
Democracy, a very ancient system of governance that can be traced back as far as 5 BC in Athens, has, throughout the years, evolved to the versions used around the world today. The word democracy comes from 2 Greek words, demos, which means the people, and kratein, which means to rule. The word is commonly translated to mean power to the people. There are 2 categories of democracy: direct democracy and representative democracy. In direct democracy, when political decisions must be made, each person casts a vote and is given a chance to directly influence the policy-making process. The second major type of democracy is representative democracy. A group of people are elected and assigned with the task of making decisions on behalf of a group of citizens that they represent. Trinidad and Tobago subscribes to representative democracy. The types of democracy can further be subdivided into systems of democracy, namely the parliamentary system, the presidential system, and a mixed system. Trinidad and Tobago uses the parliamentary system. In this structure, voters select parliamentary representatives. This system has a split executive, which consists of the head of government and the head of state. The head of government controls the legislative process, while the head of state serves as the ceremonial representative of the country. Throughout the world, there are more parliamentary systems than presidential democracies. For the 2016 International Day of Democracy, the Parliament channel decided to explore relationships between youth involvement in Parliament, the Sustainable Development Goals, and the future of democracy.
Well, I think one of the things that we're going to have to look at are the attitudinal issues, the extent to which populations themselves are aware of these Millennium Development Goals, and the extent to which those goals form a part of a public policy agenda. So it's a bit of a two-way street. The policymakers, on the one hand, the extent to which they're being guided by those goals, and on the other hand, the extent to which the population is aware of those goals. So I think that there's a public education gap that needs to be filled at two levels, one with the policymakers and two with the wider population. So for that to happen, I think the two have to come together. And I think that there will be a tremendous role for public education to take place along those lines. So that's how I think in the first instance it's going to happen.
One of the first challenges we face is that these UN agreements are seldom discussed in Parliament or discussed with the wider population. Our leaders or their representatives sign these agreements, but then there is little effort to roll this out to the wider population. And I think it's a pity because the agenda, the 2030 agenda, is quite an interesting document. It includes many developmental related issues. It includes issues related to good governance, to climate change, to equity and equality, to vulnerable groups, to so many issues that affect us.
In the second instance, you're going to need some kind of institutional adjustment. I know that the Parliament of Trinidad and Tobago has changed its standing orders and has a number of committees, joint select committees, that are able to investigate a number of aspects of public life. And that is a very positive development that to some extent is moving in the direction of the development goals. But I think that we are still some distance away, having regard to the size of the Parliament and the extent to which you have members of committees who are also ministers of government. That does create some difficulty because ministers of government obviously have ministerial responsibilities and also come from one particular side of the House. And that means that they would be unlikely to speak as freely as they would like. And the same would apply to those who are backbenchers, who belong to a party caucus and are directed in many respects by the decisions made in that caucus.
And they also mention support that the international organizations are willing to give countries such as our small island developing states support in terms of strengthening our data collection systems, or the kinds of aid that countries are willing to give. And I think that there needs to be a much more robust discussion of these kinds of agreements to which our government are a signatory.
So we understand it in the context of the cut and thrust of politics. And what I think will have to happen is how do we adjust our politics to accommodate an agenda such as that, as outlined in these Millennium Development Goals, that will require some cross-party activity.
I think, first of all, we need a broader understanding of democracy. For many persons, democracy is basically voting every 5 years. But we need more than that. And we also need democracy to be rolled down to other levels. Now, what I find is that the party system could be very divisive in many of our societies, and often these party divisions roll right down to village, community. Of course, they're there in the local government level.
I don't expect that persons will be throwing away the party whip anytime soon, but I think that the platforms for cross-party dialogue is going to be one that ought to be cultivated more widely, and that perhaps is something that can take place where we look at debates in the House and the format of those debates, the restrictions placed on those debates, the kinds of activities that take place in committees of Parliament, and the extent to which those committees are able to engage in the kind of investigation and have the kind of output that would allow them to be as effective as they could be, having regard to those development goals.
So we have to find mechanisms for non-partisan collaboration and the discussion and decision-making of issues. And I think that is going to be very revolutionary in many parts of the world. But if we are to roll down decision-making, discussion, and awareness, it has to happen in a non-partisan way so that persons at all levels can feel comfortable to be part of this decision-making and not make decisions based on partisan. So I think that I'm very happy, for example, for the efforts to strengthen local government. And I think that there should be safeguards within that to facilitate the various members working together in the interest of the community, but also stronger mechanisms to have community influences or involvement in these committees so that we ensure that there's a real link with what's happening at that level. I think also in terms of this, if we are really transferring certain power and decision making, we have to ensure that the resources are available, that the systems, the legal systems, all the administrative systems are there to allow the local government to work efficiently and effectively.
The Parliament of Trinidad and Tobago has made significant strides in ensuring youth participation in democracy. First,
Okay, thank you all. The meeting is now resumed, and I think we can continue where we ended. And that is to say, Senator Obika had posed a question. Would you like him to restate the question?
Yes, please. Thank you.
Delightfully. Thank you, Chair. The question is, has the judiciary engaged in discussions with stakeholders to develop a system which will facilitate automatic garnishing of earnings? And that was given the submissions from page 40 to 42 regarding the family court, indicating that the sentencing should be non-custodial and should not form part of the payer's criminal record, because then that may result in the payer becoming unemployable and defeats the intent of the penalty, which is to ensure that the child is assisted.
Good morning again. So as I indicated, the ability to garnish wages is a relief that is currently available at the court. It requires one of the parties to come before the court to request such a relief. And in terms of the sentences appearing on your criminal record, presently they do not appear on a criminal record, and we would, given the challenges associated with that, we were just making a comment that it should continue to not appear on a criminal record.
Thank you. There's a subsequent question, but I'm sure there are many groups of the NGOs that came before us who would be appreciative of that. And state agencies, not in the least, would be the Prisons Authority, because they expressed concerns when they came before us with the fact that if you incarcerate an individual and he is released and then he is faced with this backlog of payment, he may decide that he's not going to pay at all and then be recommitted, and then, of course, the children suffer. The second question is the Electronic Payments in the Inter and Out of Court Act 2018. How does this facilitate, or does it facilitate, does it make it easier for garnishing of salaries in terms of system flow and cost?
So the Electronic Payments Into and Out of Court Act facilitates the making of online payments. So not necessarily the garnishing of wages, but what it does, it provides us with the legislative backing to allow for online payments into and out of court, for example, maintenance. So at present, that system is being operated at the family court with the court with court pay.
So does it mean to say that the magistrates' courts don't have the facility as yet? And is there a proposal, if not, is there a proposal to have them included?
If you may recall, the Family and Children Division is supposed to be handling all family matters, but there's a transition provision. So until there are facilities available in the South and in Tobago, these family matters are still being handled in some magistrates' courts. So in those magistrates' courts, the electronic payments are not yet available, but the intention is that within the next month, they are to be so made available.
As it stands now, what do you see, or what are the gaps that you think need to be filled so this non-custodial sentencing could be effective within the court system? There must be something that is not intertwined and it's not working effectively. So what do you think you need to iron out for the system to work?
With the adults, it needs to be more permissive of the judicial officer with less red tape. The resources need to be available, made available, not just to the courts in terms of the wraparound services, but also to the other agencies in the system. And I think that is basically it. And I think when it comes to the children, it's, maybe my colleague will speak specifically to that.
When it comes to the needs of the children, we really have to focus on establishing the appropriate community residences for children who are at medium to high risk. At this time, I can tell you our daily routine, sometimes we have children at 7 o'clock at night and we have no place to put them because some of the homes refuse because they are either filled or they are unable to handle a child of that nature. So a lot of focused attention really needs to be placed on community residences that are appropriate for children who are high risk, with all the necessary staffing, interventions, programs, ensuring there's transportation for children to go to court-ordered programs so that they could get back on track. Of course, as well, for drug treatment, to have facilities that are specific for children and service providers who are able to deal specifically with children.
Do you have any system in place to monitor these children?
What aspect of the monitoring?
Perhaps we could deal with the post-sentencing.
Well, child probation officers.
But then we don't have sufficient. So is it effective?
Well, at this time, what the court would usually do is to do an order when that child needs to return to court. And the child is returned to court based on the court order, so that the judicial officer could determine how well that child is doing, whether some of the interventions that are ordered for the child, how things are working and progressing, and whether there is need for additional interventions in that child's life.
Okay. A member of the public sent in a question. Now, it doesn't strictly fall within the ambit of the inquiry, and Senator Obika will forgive me, but since there are persons here with knowledge about the family court and how it works and so on, perhaps someone may be able to provide the assistance to this member of the public. And the question is, are there any services in place to assist parents and guardians to identify usage and how to seek professional guidance and assistance to address the issue of minor intoxication? So I suppose it covers not only alcohol, but it may cover, you know, glue or whatever else may cause intoxication.
I don't think that is really within the ambit of the court. We do have to remember how any matter, whether it be for a child or an adult, comes to court, and that is that it will start either with a charge or with an application. So that which is purely advisory would really be within the hands of the executive and of NGOs.
Perhaps you could just tell me, is there an agency that such a parent can go to for advice? Or would it have to be an NGO?
I really would not want to venture. I mean, the Children's Authority would have certain types of a certain type of rule, including a referral rule. So a parent looking that particular way may quite possibly seek the advice of the Children's Authority or of National Family Services.
I just have one last thing that I would like to get your view on, and that is to say, in the UK, there is a system whereby a young offender might be cautioned instead of charged and placed before the courts. Do you think there's any benefit to have that included in our system?
Our legislation provides for cautioning only in certain types of matters at this point in time. That was something which was looked at quite heavily when we were looking at both the Children Act 2012 and the Family and Children Division Act. And one of the things is that one of the difficult issues in something like that, which is really a sort of out-of-court disposition, has to do with the exercise of that particular authority and public confidence in the equal exercise of that particular authority. And it was felt that some work had to be done first in order to give the public comfort and in order to train the police service in how to handle that before it could venture in that particular direction. That was the view of the joint stakeholders.
Thank you. I think we have had a lot of information, a lot of useful material which we can use for the purposes of the drafting of our report. So unless there is any other question. Yes, Senator Obika.
Thanks, Chair. Final question regarding the electronic monitoring system, and if the judiciary can give us some ideas to the possible impact on ability to supervise offenders who are placed under community service orders. What would be the benefits of such a system in terms of electronic monitoring? What would be the challenges? And how you think we can mitigate against that?
Thank you, Chair. The judiciary has expressed its support for the electronic monitoring system and has actually had quite a few meetings with the team from the Ministry of National Security. It is felt that it is a very good option for dealing with certain things. Number one, for dealing with persons on bail or for dealing with persons who may be on probation or who may be on a bond. So there are definite pluses. And also in matters involving domestic violence, it also presents a valuable opportunity to assist the victims of domestic violence. So there is tremendous support for that. As to the challenges, we just have to make sure that we get it right. We must make sure that our GPS systems are in place and that everything is targeted and on track.
Okay. Thank you, Master Morris Allen. I now invite you to make a few brief closing remarks.
Thank you, Madam Chair. Madam Chair, first of all, I do want to correct something that I stated. And that was when I stated that in the first 2.5 to 3 months, we had crossed the 1,500 mark. It is that we had crossed already 1/3 of the 1,500 mark in the children court for children matters. So I wanted to correct that. I would not want to make any statement to the Parliament which is incorrect in any way. But generally speaking, it gives me pleasure to be here and to take part in what you had called an auspicious occasion. I don't like the word either, but we must admit that it is a historical occasion, and the Judiciary is very pleased to have been able to assist the committee in any way in which we have been able to assist the committee. We'd like to thank you very much, and also to thank the staff of the Parliament and the staff of this committee for earlier discourse with us. As you know, we have begun and we have drafted a sort of first-level protocol for the interactions between these two arms of the state. And I look forward, and on behalf of the Judiciary, we look forward to a good relationship in this regard and in a good sharing of ideas. So again, thank you very much for having us, and thank you very much to the committee and to the staff.
Thank you to you and your team. I will also like to thank the media, persons in the public gallery for attending, and our viewing and listening audience. There being no other business, this meeting is now adjourned.
Thank you.